On Thursday, February 5th, newly appointed Attorney General Pamela Bondi issued a series of memos to Department of Justice employees, including one impacting DEI in the private sector. The memo, entitled Ending Illegal DEI and DEIA Discrimination and Preferences, sets forth the DOJ's plan to investigate, eliminate, and penalize illegal DEI and DEIA preferences, mandates, policies, programs, and activities in both the private sector and in educational institutions that receive federal funds. This memo largely tracks the executive order issued by President Trump, which we discussed in a prior Labor Speak. In line with that executive order, the memo instructs the Civil Rights Division and Office of Legal Policy to submit a report of recommendations by March 1st addressing key sectors of concern within DOJ's jurisdiction and the most egregious and discriminatory DEI practitioners in each such sector. The report will also address specific measures to deter the use of DEI programs that constitute illegal discrimination or preferences. Per the memo, this should include proposals for up to 9 potential civil compliance investigations of entities previously identified by President Trump's executive order, which include publicly traded corporations, large nonprofit corporations or associations, foundations with assets of $500 million or more, state and local bar and medical associations, and institutions of higher education with endowments over $1 billion. Notably, the memo also discusses proposals for criminal investigations, which were not referenced in the executive order. Additionally, the DOJ report will propose other potential litigation activities, such as interventions in pending cases, statement of interest submissions, amicus briefs, regulatory actions, and sub-regulatory guidance, as well as other strategies to address the administration's concerns with unlawful DEI practices. The memo also indicates that the DOJ will issue guidance to educational institutions that receive federal funds, in line with the Supreme Court's decision in the Students for Fair Admissions versus Harvard case, which found colleges' use of race-based affirmative action unlawful. What exactly constitutes illegal DEI remains to be seen. According to the memo, it is meant to address programs, initiatives, or policies that discriminate, exclude, or divide individuals based on race or sex. The memo does explicitly allow for educational, cultural, and historical observances that celebrate diversity, such as Black History Month and International Holocaust Remembrance Day. The DOJ's memo and forthcoming recommendations are likely to be subject to legal challenges, including on potential First Amendment grounds. However, as has been reported, and as we have heard too, employers have already made changes to their DEI programs, such as eliminating DEI teams, removing references to DEI initiatives in job postings and websites, and abandoning aspirational hiring goals. Given the Trump administration's focus on DEI and the prospect of civil and criminal liability, we recommend that all employers conduct an audit of their DEI policies and practices. This should include a review of all outward engagement and communications regarding DEI. It should also include a review of all internal initiatives, policies, and procedures touching on diversity, equity, inclusion, and accessibility, such as trainings and hiring practices. Aiken's team is available to answer any DEI questions you may have or assist you in conducting a complete DEI audit. And to stay up to date with the latest developments, continue to follow our Labor Speaks as well as Aiken's Executive Order Tracker linked in the cover email.